In what has been called a blistering lawsuit, Karen Reed strikes back at major police officials who had gone after her in 2 trials. That's what the media is calling it, a blistering lawsuit. Plus, a big surprise in the Brian Walshe case in this episode of About the Law.
You lost. And you know what you did.
Yeah, Karen Reed was acquitted of all major charges after 2 trials, but that doesn't come even close to ending the legal matters surrounding the death of John O'Keefe. I'm attorney Andrew Myers. This is About the Law. Joining me is co-host, California attorney Yolie Medina. Hey, Yoli, how are you?
I am fine. How are you?
Not bad. Just, I went into the office on November 18th thinking just another day, get some work done. And then I figured, I'll watch the Brian Walshe jury selection. And he pleads out to 2 charges against him. And we'll talk about that in a bit. But that kind of shocked me. Did that shock you?
Yes, especially the charges that he pled to.
Yeah. So I want to talk about that. But first of all, the blistering news, and that's what the local media is calling it, is that Karen Reed has filed a lawsuit with 6 counts against the police officers that went after her and the McCabe's and the Alberts. And I hate to read every single word of it. But what I would say about the complaint that was filed on November 8th, actually, it was filed on the 17th, but it became public on the 18th when it hit the electronic dockets. The thing that shocked a lot of people about the complaint is that it's 46 pages, 172 paragraphs, and 7 counts. So let's just kind of jump right into it. There it is. There's the first page. It is Karen Reed versus Michael Proctor in his personal capacity. Note that they're not suing him in his capacity as a former Massachusetts State Police officer. In his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Lieutenant Brian Tully in his personal capacity, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Now, I'm not going to play Let's Stump People, but look who's missing from there. Colin Alberts. He's missing. He's not in there. But in any event, this is
There's a footnote, though. What does the footnote say?
Interesting. Okay. So I just read all those. I just read all those defendants. Footnote 1. The Massachusetts State Police and Town of Canton will be added as defendants after presentment is made pursuant to General Law 258, Section 4. What that's all about is, do you have a tort? I think you have a Tort Claims Act out there in California. Yes. Back in 1978, the legislature in Massachusetts adopted the Massachusetts Tort Claims Act. What that's all about is in the old days over in England, they had respondeat superior or, which meant that the king can do no wrong. And you couldn't sue the king or the queen or anything to do with government. And that concept was kind of brought over here to this country. And even after the Revolutionary War, that general common law concept remained in the law until about the 1970s, when the federal government, a lot of states said, well, all right, we'll let you sue us, but you got to follow procedural guidelines. So the Massachusetts Tort Claims Act, or MGL Chapter 258, says you got to do a bunch of stuff. Would take me an hour to teach the whole thing in a continuing legal education seminar, but basically what it walks down to is if you want to sue a governmental agency in Massachusetts, you have to do what's called presentment. You have to send a formal demand spelling out the facts, proving your damages and sending it to the right person, whether it's the state or the transportation authority or whoever it is. So you got to send it to the right person. Then under Section 4, which is down in the footnotes, the state or whatever governmental agency you're suing has 6 months. If they deny the claim, only then can you file suit. If you don't follow that procedure, you're going to get the case dismissed. So anyhow.
Yeah, that's the same in California. I mean, you have a certain amount of, you file the claim and then they give you a certain amount of time. And then when they deny it, then you have jurisdiction to file it in the California court. And then I guess if they don't respond by, I think it's a number of days, 45 days, it's denied by operation of law, and then you can file it.
So that's what they had. So they brought in all the people that you see there that I just read, but they can't bring in the town of Canton or the Massachusetts State Police until they go through that procedure. And of course, we have to assume that they have already initiated that. So the other footnote, interestingly, says that plaintiff intends to move to consolidate this action with the related action, which we've talked about before, estate of John O'Keefe et al. Versus Reed et al. And we've talked about that one. Interestingly, that one was brought in Plymouth County because Paul O'Keefe lives in West Bridgewater, which is in Plymouth County. This one we're talking about now was brought by Karen Reed and filed in Bristol County because she's now living in Dayton, Massachusetts. So the procedural...
And that's in Bristol County, right?
Yeah, where Karen lives, yeah.
Yeah, okay.
So it starts out by saying, for 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police. And we'll call them MSP from now on, just easier. And those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in, she says, actually involved in Mr. O'Keefe's death, and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022.
So number 2 says Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton, and they're going to refer to that address as house.
Right.
In an altercation during a late night house party with other defendants, collectively the house defendants. After a night of heavy drinking, the house defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the house defendants conducted a Google search for information about Haas Long to die in the cold, moved Mr. O'Keefe's body outside, and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts' lawn until Karen Reed found him later in the morning.
I find 2 things about that paragraph that you just read really interesting. A, remember there was a hearing and Judge Canoni denied Karen Reed's motion to allow the third-party culprit defense. Mm-hmm. And so I would think that these attorneys have done their homework. I don't think that they would say all of these things unless they had some basis for it. Go down to the bottom, all the way at the bottom, you have 1, 2, 3, 4, 5, 6 attorneys that signed off on this. And under Rule 11 in Massachusetts, the same as Rule 11 in federal court, you have to have a good faith basis for your pleadings. You must have a good faith plea. You can't just pull stuff out of the air or someplace else. So what I'm saying is that anytime you file in any court but particularly in Massachusetts under Rule 11, you must have a good faith basis. So keep that in mind as we, go through this, that if you think, oh, they just made it up, they wanted to bring this into the criminal trial and the judge wouldn't let them. And B, I've got to believe that there was an investigation and that they believe all of these facts that they've set forth here under 6 signatures of 6 attorneys. So the third paragraph is that from the beginning, investigators from the MSP allowed the House defendants, that's what they're calling them, to direct the investigation away from themselves and toward Ms. Reed. Now, if you follow the local talk, they call them the McAlberts because it's a blend between their names. But now in this complaint, they formalized it from the McAlberts to the House defendants. And they say that the House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. We don't know how much longer now that he's no longer with the Massachusetts State Police, having been dishonorably discharged, but I digress. Proctor has been and remains close personal friends with the Albert family. This is really important to this complaint. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. They don't say it here, but he worked out of the Canton Police Department.
Yeah. And adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of the head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike.
And that was something that really had a lot of people scratching their heads during the trial. How can the Commonwealth's own medical examiner not be able to say that it happened the way that the prosecution said it happened? I mean, that was extremely unusual. Yeah. This, so far, the first 4 paragraphs, I should say, really read like almost a novel. Almost, I would really recommend this to anyone who hasn't heard about Karen Reed, if there's anybody out there at this point. But the other thing is, bear in mind that there are, 7 counts to this complaint. And what they need to do in this complaint is for each count, for each charge, for each civil wrong, there are different elements, and they have to fill all of those elements. They have to provide allegations in a complaint that fill each of the allegations that they're going to charge down in the counts that we're going to get to in a minute. So they have to do it in a somewhat technical way. But this complaint, unlike a lot of complaints, actually does read almost like a novel, doesn't it?
It does, actually. It tells a story.
Number 5 is that despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures, propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the House. Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he, Brian Albert, is a Boston cop, and that Proctor was determined to make the investigation cut and dry by bringing charges against the girl, and that's in quotes. Indeed, Proctor made his intentions clear in writing. Karen Reed had zero chance of skating. She's effed. The pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house.
Okay, that's crazy. Okay, number 6. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Wow.
You know, it's just incredible that they didn't go into that house. I know some law enforcement. That I talk to socially. And when this case comes up, they shake their heads and say, anyone, anywhere that has a murder in their front yard, the police are going to go in there and or get a warrant so that they can go in there, and they're going to cordon off the accident scene, the crime scene, which was never done here. It's just outrageous. And in fact, one of the things that the jury foreman said in interviews after Karen Reed was acquitted of all the charges, and he had a photographic memory, or an eidetic memory, I should actually say. He had an eidetic memory and a very good memory of things that happened in this case. And one of the things that he said is, if they found a body on my front yard, they would have been in my house. So,
it's just common sense that they would go inside the house. I mean, it's common sense to most people because that's what investigators do. They investigate, they poke around, they look around, and it just doesn't make sense. They didn't go in the house.
Yeah, this is just bizarre. I mean, you don't have to be a trained investigator to know that was just a real failure. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device, and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Ms. Reed.
Thank you gift, huh?
Yeah.
Number 9, Proctor then went so far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack.
And the thing that's just standing out in my mind here is, if you're an investigator, you keep everything in mind. And only when you get the evidence do you sit down and go over it with your fellow investigators and narrow it down. You don't start out with, oh yeah, she did it, and then, close your eyes to every other possibility. That's pretty standard police conduct, and they talk about that later in this complaint. But remember in the, not that they needed it, but remember in the second trial, the defense attorneys had an expert who was a former FBI guy that was going to come in and talk about crime scene investigation, and Judge Cannoni said, no, can't have it. Number 10, far from conducting an objective investigation with integrity, Proctor personally and dehumanized Ms. Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, and this is what I was referring to before, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed is a whack job, a see you next Tuesday. I don't think I can even say the next R word, a nut something, and a babe with no butt. Proctor further ridiculed. I hope that Facebook doesn't strike us for that. But
Facebook, you mean YouTube?
Yeah, YouTube. Yeah. Facebook would definitely do something, wouldn't they? I think they do. Proctor further ridiculed and derided Ms. Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text messages to his MSP super, I worked in a warehouse after I got out of high school, and I never even heard that. I never heard that last part. The other things, sure, I heard. I never even heard that. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Ms. Reed's phone, he was looking for naked pictures of Ms. Reed. Disappointed, he reported that there were no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully she Ks herself. It's just...
Yeah. Wild.
I'm speechless.
I know. Number 11. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yolie Medina, responded with a thumbs up emoji to a text calling Miss Reed the R word. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Ms. Reed, demonstrating a clear prejudice against her from the outset.
Oh, Proctor is just the non-gift that keeps on giving. 12, relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Ms. Reed and knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Ms. Reed, but they also form the foundation for Ms. Reed's claims against the defendants. These acts violated Ms. Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. So now, just to explain this a little bit, there is section 1983 under the federal law, which is civil rights violations under federal law. But Massachusetts has its own law, which actually extends a little bit further in terms of protecting people. It's the Massachusetts Civil Rights Act. And later on in this document, the attorneys explain that, yes, the state court has jurisdiction over both the federal and the state. And so that's why they're pressing it all together.
Well, that's the same with California. California has their own civil rights statute, and then there's a federal statute.
Yeah. And so one question that I think has come up is, there was a hearing in the case against Karen Reed that had been brought over in Plymouth County by Paul O'Keefe, when Karen Reed's attorney, Mr. Seligson, stood up and said, we intend to bring as many as 10 different defendants in, and we intend to bring all of these claims, including the civil rights violations. And they brought that up to that judge in that case, and I think it's fair to say that the judge's reflection on that was not warm. It was a cool response. And so I am wondering if the attorneys who wrote this complaint regrouped, talked, figured, instead of bringing all the people and all the different counts, there are 7 in this complaint, bringing them all into that county Plymouth County and allowing that judge to pick and choose and knock some of them out. Why don't we bring everything together? All of the defendants that I named up at the top of this document and all of the counts, including the ones they're going to bring later on against Canton and the Massachusetts State Police, bring it all together as one ball of wax, then try and consolidate it in either county. I'm just wondering if they made that strategic decision to not let the judge over in Plymouth County pick and choose and knock stuff out. Just my thought.
You also have the statute of limitations. They probably didn't want to lose that. And if it gets kicked out, there's a judgment. I mean, if it gets kicked out on a motion to dismiss or a motion for summary judgment, if some of these claims get kicked out, they won't be able to refile. So there will be res judicata, meaning res judicata is when there's already been a decision. So if they just keep it separate, file it in another jurisdiction, then they get all their claims in and then they can consolidate it. Because I was sort of confused about what they were trying to do with bringing in all these claims, but Mark Bederow kind of put it in perspective that she's going to be using these actual claims as her defense.
Exactly.
So it kind of makes sense. Yeah.
You know, it's the same nexus of facts. It's the same commonality of facts that are involved in both suits. And so it makes really little sense at all to try them twice in two different counties. And so it would seem in the interest of judicial economy actually to put them together. So that's why I think that they did not bring it as counterclaims and a motion for third parties to bring in the other defendants. Yeah. I think that's why they strategically brought it over in a different county, Bristol County, which they didn't have to do. In any event, we start up again on June 18th, 2025. After a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe, and also that Mr. O'Keefe's injuries did not come from a vehicle strike. That's the ARCA experts. Although Ms. Reed, go ahead.
I was just going to say that's what it boils down to.
It does. For
me, anyway.
I think for a lot of people, I mean, those guys started out and the judge tried to hammer, Alan Jackson. I'm shocked. And in any event, but the ARCA experts started out as independent. They were hired by that other agency, which we all know who it was. So they started out independent. They owed nothing to, and they were being paid by neither side in the Karen Reed litigation. And they came to that conclusion that a car did not strike John O'Keefe, and John O'Keefe's injuries were not caused by a car strike. So how this could go forward, really, I mean, the federal government never brought anything, and it just, I can't believe that the people in the Norfolk County District Attorney's Office saw fit to go forward. But to finish that paragraph out, although Ms. Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought nor provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Ms. Reed. And we went over all those disciplinary actions against all of the police officers they're talking about here in our previous episode. So I'll link that previous episode down below.
All right, number 14. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, quote, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in this regard." In an interview with the Boston Herald, Noble acknowledged the systemic nature of MSP's conduct in Ms. Reed's case. Quote, "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor." Unquote. "These hollow words do nothing to right the devastating wrongs that have been visited on Ms. Reed." Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it.
I yellowed that paragraph because I thought it was kind of telling.
I mean, I just feel bad for Karen Reed. It's like a witch hunt.
Well, and she had some bad cops. They just went overboard. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included, quote, that he was biased in his dealings with the homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute. And that's really important. If the lead investigator, and they tried to back away from that reference in the second trial, but he was the lead investigator. If he starts out biased, I mean, the fish rots from the head down, and it's just the whole investigation is brought into serious question. And that's why this is blown up. That's why we had 80 different countries, following us in our humble little podcast, because it's shocking. It really is.
Number 16, Miss Reed's life was not merely turned upside down by the MSPs and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoings. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks at a minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own.
Okay, so that's the initial statement of facts. Usually in a complaint, a statement of facts is a paragraph or so. And here we have 16 paragraphs. We're going to skip over everything here just to point out what we pointed out before. The parties are Karen Reed, Michael Proctor, Yuri Buchanan, Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. So now they explain jurisdiction and venue. This court, I mentioned this before, this court has jurisdiction over all of the claims in this case pursuant to Mass General Laws, Chapter 12, Section 111, and with regard to the federal claims pursuant to Reziznik versus Chief of Police, a 1978 case. Venue is proper in this court pursuant to Mass General Law 223 because at least one party to this case, plaintiff Karen Reed, resides in Bristol County, so she can correctly bring this case in her own county. So now, some of this is a little bit repetitive. They're talking about facts common to all counts. Where we're going here is the 7 counts that follow. So what they're doing here is organizing the facts that we just read. We've read substantially all of the facts in this case. Now they are organizing them in a manner that they can fit them in to the law that allows for the counts that they have. So facts common to all counts. Mr. O'Keefe's death, 28. Before his death, Mr. O'Keefe and Ms. Reed were dating.
29. On the evening of January 28, 2022, Mr. O'Keefe and Ms. Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton.
There, they met up with a group of acquaintances, including Brian Albert, his wife, Nicole Albert, Brian's brother, Chris Albert, and his wife, Julie, Jennifer McCabe, Nicole's sister, and Brian's sister-in-law, her husband, Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road, quote, the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. This complaint really is a who's who. It's an index. It's kind of fitting everyone together. So I think it's a really good reference for anybody that wants to catch up on. If you didn't follow the Karen Reed criminal trials, both of them, this is a good way to get up to date on what it was all about.
Number 31. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other very well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor.
Yeah, they sure did. They went out drinking together in a cruiser. That's in here somewhere. I'm not making that up. 32, Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, who I'm surprised he's not named as a party defendant in this complaint. Colin Albert, Brian Albert's nephew, was present.
33, Ms. Reed and Mr. O'Keefe had never been to the house before January 29, 2022. They arrived in front of the Alberts' home around 12:20 a.m. Ms. Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late night party. Mr. O'Keefe got out of Ms. Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door/garage door area of the house and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Ms. Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him.
At some point after entering the house garage, Mr. O'Keefe was involved in a physical altercation, either inside the house or garage. During that altercation, the Alberts' German Shepherd, by the name of Chloe, attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. I wonder if they'll bring in Dr. Marie Russell to this case. She's probably tired of testifying. She testified in trial 1. She testified in trial 2. She was voir dired before the second trial. So good grief. He also suffered an incapacitating injury wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backwards and striking a ridged surface. The Alberts' garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts.
All right, 35. Because of their knowledge of criminal investigations, the Alberts, the McCabe's, and Higgins house defendants knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least 5 of them agreed on a simple plan to exonerate themselves and implicate Ms. Reed. They would tell anyone who inquired, Mr. O'Keefe never entered the house, and hide evidence that he was there, including his body.
So sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passersby. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, to where one or more of them later claimed Ms. Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Ms. Reed's vehicle and then died as a result of exposure to the cold.
37. Mr. O'Keefe was either dead when the house defendants left him on the Alberts' lawn, or he died shortly thereafter.
I highlighted the next 2 paragraphs because they really stand out. And if people are questioning, wow, we've read about some of this and heard about some of this in social media, but it didn't come into the criminal trials. That's because the judge denied a motion to allow the third-party culprit defense. So after the physical altercation, Higgins left the house and drove to the Canton. Oh, this is amazing. And Microdots actually did an incredible episode on this. If you haven't seen it, check it out. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some more administrative work. Who does administrative work in the middle of the night, especially after having a few adult beverages? But,
yeah, that's true, especially if you're law enforcement.
Yeah, I mean, I then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away.
Number 39. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls, and then when confronted with their existence by a separate law enforcement agent, a non-MSP and non-CPD law enforcement agency, at a separate proceeding, they coordinated the same exact lie, falsely claiming that the multiple calls and answers were just butt dials. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m., quote, "Hast long to die in cold," misspelling the first word.
Now, I actually did get a butt call about 2 weeks ago. Someone who I won't dox here. My phone rang, and then it was hang up right away. And then the person that had accidentally butt dialed me said, "I'm sorry, I didn't mean to do that." And that's I hadn't had a butt dial for probably about a year. It does happen. It does happen. But that many times in one night? What?
It happened to me twice in 1 month.
Twice in a month? Yeah, but it doesn't happen 20 times in one night, does it?
No.
I mean, it does happen. We're all careless, or I don't put my phone in my back pocket because I'm afraid I will break it. But I see a lot of people do that. But it doesn't happen that many times. Now, I think a lot of our regular viewers are familiar with the facts that are set forth here. So I'm going to jump down to the bottom and just point out that all these facts are intended to fill out, the 7 counts that are brought in the complaint. So we'll just go over the 7 counts. Because those are the issues here. Here's one little thing I starred. Proctor, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. Isn't that interesting?
Well, yeah, I mean, that's the number one thing you would do besides going into the house and poking around.
That's standard stuff. I mean, that's standard stuff. So here we go. Count 1, 42 U.S.C. 1983, malicious prosecution under the Fourth Amendment. That's against Proctor, Buchanan, and Tully. And they just pretty much recount the facts that are stated.
She couldn't bring it against Hank Brennan because the prosecutor has immunity. It's very difficult to sue the prosecutor.
Right. Count 2 is also a USC 1983 civil rights claim. It is supervisor liability against Buchanan and Tully in their individual capacities. So they're going to have to go out and get their own attorneys. I would imagine that the union will jump in and defend, but it's likely that they will get their own attorneys also. So it's likely there will be a couple of attorneys for each of these guys. I was involved in some 1983 litigation not that long ago involving a police department. Police department had its own attorney. The city attorney came in. But with respect to the individual police officers in Massachusetts, the union came in and provided one attorney, and then the police officers themselves had their own attorneys. So when we did a deposition in my conference room, was pretty crowded, very
Right.
crowded day.
And, in California, the individual police officers can be sued for punitive damages, not the public entity, but the individual police officers. So frequently they have their own attorney to help to defend them, and aside from the city or the county or whatever entity
Yeah,
it is.
that's interesting. Then count 3 is yet another 42 USC 1983 claim, conspiracy to deprive Ms. Reed of her Fourth Amendment rights. Count 4, Massachusetts Civil Rights Act, which is different from 1983. It's the same intent, but it's the Massachusetts Declaration of Rights upon which this is based under the statute, actually provides more protections to defendants than the federal Constitution, which is interesting. But this is a claim under the state civil rights action against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. Count 5, common law malicious prosecution. Common law means a state law. Common law is just developed not by statute, but over the years through cases that are decided by the courts. Count 6, intentional infliction of emotional distress against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. Number 7.
That's to be distinguished from negligent infliction of emotional distress.
Right.
This is intentional, intentional acts.
I was kind of surprised by that. Because it's a larger bar to get by.
It is, yeah.
But there are cases in the Massachusetts law books for intentional infliction of emotional distress. Count 7, civil conspiracy. So not only are they charging them under the federal statute 1983, they're bringing a count for civil conspiracy. And the facts that we've just read underlie this count. And all I'm skipping here is them putting together the facts that we've talked about before, putting them together and organizing them so that they make out a complete claim under all of these statutes. And so now those are the 7 counts. And I think people have a question under this because I read some articles that have already appeared in the press. Karen Reed is seeking an undetermined amount. Karen Reed failed to state in her complaint how much she seeks. Well, in Massachusetts, we don't do that. The rules in Massachusetts prohibit an ad damnum clause. And what an ad damnum clause is saying, I want X amount of money. Now, the lawyers can argue it in their closing arguments. They can specify what they're seeking and how much they're seeking. But that's why the prayer for relief says that under B, award her damages in an amount to be calculated at trial along with pre- and post-judgment interest, costs, and expenditures. And number C, award her reasonable attorney's fees incurred in connection with the litigation pursuant to 42 USC 1988. And I guess originally when Massachusetts did that, they felt that it would be too suggestive and prejudicial for the jury to see a number. So we do not put a number. I remember a long time ago, there was actually a case of a young attorney just out of law school, put a number in the complaint, and there was a motion to strike immediately because we just don't do that. I know some states, and you and I have both read complaints where there's a dollar amount, there's an ad damnum clause, but we are prohibited from doing that in Massachusetts. We're
prohibited from doing that. Now, the government claim or the presentment of the claim to the public entity might have you might have to state an amount. I don't know what the statute is there, but in California, you do for the government claim, not the complaint, but this is the presentment of a government claim where you have to sue the government. You got to go through that first. They have a provision where you have to state an amount. So most attorneys state an astronomical amount because they don't want to be limited, because you are limited to the amount that you state in the government claim. So the government claims are public record. So I don't know if anybody has gotten at least in California and Washington they are. I don't know if anybody's gotten a hold of the government claim in this case, or if it's a public record. It should be.
I've done them. I've never seen them as a public record. I don't know if they would have under the Massachusetts public record law or FOIA. I'm not certain that that would have to be disclosed because that's something that's in pending litigation. So that's a difference between California and Massachusetts. That's a difference. So
I know Washington. I know that Washington for sure. You can request a government claim under the FOIA. In California, I believe that's true. I'm not 100% sure, but
I've just never seen it. I've just never seen it. Maybe I've never really. I have done them. I've done a bunch of them. I've done a bunch of them over 30 years of litigation, but I've never seen them become public. I did one. I'll tell a brief personal story before we move into Walshe. I did a presentment and a lawsuit over a Massachusetts State Police trooper that was on Main Street in a town near one of my offices in Massachusetts. And the Massachusetts State Police trooper went up past Dunkin' Donuts, then did a U-turn to go into Dunkin' Donuts, and they hit my client. So my client was injured, but he recovered. And so we had to do a presentment against the Massachusetts State Police in that case. They didn't really want to settle it for what we felt was a fair amount. So we did put it into litigation, and they settled it. They settled it before trial. So the press, it wasn't a high-profile enough thing that it hit the press. But they felt like if it did go to trial, the reporters do go to the courthouse. Probably not so much anymore, but the reporters did go to the courthouse and rifle through the files. So anyhow, any questions about the complaint, let us know. Let's turn to Brian Walshe. He goes into court on November 18th. Supposedly they are going to do jury selection. That was going to last for 2 weeks. I think everybody was shocked that Brian Walshe pled guilty to 2 counts against him. Not the first degree M, but what he pled guilty to were willfully misleading a police officer and willfully conveying a human body. So and this was not a plea deal. The Commonwealth did not even want to talk to Mr. Walshe unless he was going to plead to the first degree M charge, but he didn't. So that was a surprise. The judge, Diane Frenier, conducted a colloquy as she must, and she accepted it. He's not been convicted yet, but he has those pleas have been accepted, and he'll be sentenced later. So that was a bit of a shock, and we're all wondering, how is that going to reshape Brian Walshe's trial?
I don't know, but you would think that normally what they do, and I don't know, I mean, this is my thought, that you would plead guilty to the lesser charges and they would dismiss the murder charge, but him pleading guilty to the lower charges, maybe that means that less graphic evidence is coming in?
That's some of the speculation. The real thing that in the public view cooks Mr. Walshe, to use a non-legal term, was all of those searches that he did. And we've done a couple of episodes where we've gone through them or alluded to them, and they all go to disposing of a body. How do I dispose of a body? What's the best tool to use to dismember a body? What does formaldehyde do? When does a body start to smell? So all of those searches that were done on his son's tablet, they were all towards dismemberment and not how to M a body. So It's possible that the theory is, well, now that he's pled guilty to that, those are not at issue. So there will likely be an objection to even bringing those in. If that's true, and if that objection is sustained, that takes a lot of wind out of the sails of the prosecution. And that really is an amazing strategical move. My own impression was that it's possible that his attorney, Kelly Porges, may have been behind this. I don't know. This is my speculation, because in my observation, it seemed that Larry Tipton, who was sitting behind Mr. Walshe for the most part, didn't look happy. Now, I don't know. I hate when people read into my facial expressions, my thoughts. So if that's not true, my apologies to Larry Tipton. The other possible read into that, no pun intended, the other possible interpretation is, he's charged with first degree, but if they take a lot of that out, they may not have intent. They may not have intent, which is, motive is never an issue. They don't have to prove motive, but the Commonwealth has to prove intent. So now, if they don't really have that with all of this other evidence, it may be that the Commonwealth doesn't have a case. There's no body. We have blood. We have hacksaw. We have bone. But as you pointed out, there's a question as to whether it's even human bone. So, it's possible that the Commonwealth is sitting around saying, we don't have first degree. Maybe we have to bring it down to a second degree. So I don't know. This is all speculation. I've heard other legal commenters, also speculating and admitting that it's all speculation, but it changes the trial. It changes the trial. If you spend 3 years planning a trial and putting it together, and at the last minute, 2 of the 3 counts are knocked out, you're back at your office scratching your head. It's unusual. It's unusual. It's very unusual, but it happened. It's Massachusetts. Come on now. It's Massachusetts. You never know. Every day is a new day in the courts in Massachusetts.
I listened to that hearing like on a 2x speed.
Well, I had an appointment this morning, and so I got into the office late, and I got in about halfway through, and I'm like, wait a minute. I thought we were picking a jury today. What? Huh? What? What's going on here? And so I came in right in the middle of the colloquy where she's asking him, is this truly what you want to do? And are you pleading this because it's true? Did you do that? And so he has not been convicted and he has not been sentenced. He has just made a plea, and the plea has been accepted as to those 2 counts. Counts 2 for willfully misleading law enforcement, and count 3 for willfully conveying a human body without any legal authority. So, wow. Surprise. We could do a whole episode on that, but both of these things happen simultaneously pretty much. So here we are.
I'm so blind to what was going on. I mean, I tried to listen to it but
it's okay. That's okay. So, what I forgot to do is to tell people that we're really looking to boost our subscribers. And once we get to 50,000, I won't subject you to this.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Subscribe, like, and share if you like us, or even if you don't. Still. Any closing thoughts, Yoli?
No, other than I was a little confused about Brian Walshe. Sorry about that.
It's a very unusual case. It's a very unusual circumstance. And this is our midweek episode. It went longer than we thought, only because so much has happened. And everyone be nice in the comments section and everywhere else. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.